Welcome to Child Custody University, Module 5, Parental Alienation Syndrome. This document is prefaced with this information. The founder of Child Custody University, James Feehan, had children suffer from parental alienation syndrome, PAS. He has not seen them in many years. They are all over 18. It was a lost struggle almost since their birth. They were 9, 11, and 14 when the alienation succeeded. He went through several hearings and trials, experienced representation with several attorneys, and had personal experience with several expert witnesses. He has yet to meet one who has a depth and breadth of knowledge that he acquired over the past 15 years. The knowledge necessary to facilitate change enables a person to gain knowledge of a given situation and correctly apply it to a legal rubric offering a positive outcome, whether in a trial, negotiations, or in therapy. In very simple terms, parental alienation is when an alienating parent indoctrinates their child or children into a culture of hatred and disrespect toward the target parent. It is evil and most often a result of the alienating parent suffering from a personality disorder that requires them to blame others, take no responsibility with a secret fear of being abandoned and being an ordinary person. These fears, generally speaking, are developed in childhood. Their parents create an environment that is emotionally unstable, without the sense of security necessary to properly develop children into healthy adults. Here are some examples of what alienation looks like based on what my children experienced. This is taken directly from audio that James's now alienated son recorded of his mother, as he tried to convince James of how bad it was when he spent time with his mother. The audio is not being played here because James Feehan's son might find it disrespectful to have his voice revealed. What I am going to do is offer quotes by his mother using a female voice to establish a context of what alienation looks like in a raw form. This is a conversation between Jennifer and James's 12-year-old son. Mom, I'm sorry, am I not being nice enough to the man who stole my children? Son, he didn't steal us. Mom, want to know something? I'm going for full custody. I want you all the time because your dad's putting poison in your fucking head. Son, it doesn't sound like a lot of fun right now, just to let you know. Mom, the man stole my kids. Son, he didn't steal us. Mom, why do you think that? Mom, why, you don't ever have to call me. Why is he so fucking important? 'Cause you know why he's fucking scary. Son, Mom, I need to call Dad. Mom, well, you don't call me, goddammit. What's it gonna take for you to understand? Why don't you fucking give a shit about me? What is it? I am being fucking serious. Why don't you fucking love me? Son, can I please call Dad? Mom, yeah, and you want to know why? 'Cause I know you're fucking scared of him. Son, I'm not scared of Dad. Mom, yeah, you are. That was a mild exchange, but a perfect example of the foundation of alienating behaviors. Here is a bit about another interaction Jennifer and all three boys. The oldest boy was recording because when he went home to Dad's house late without getting anything done, his dad, James, had questions. When James would ask Mom about the events and why nothing got done, the stories were much different. The boys claimed it was chaos and nothing could get done, while Mom said they refused to take showers and do homework. This audio is extremely disturbing and is over an hour long. The children were at Mom's for an evening visit, as Dad's house was their primary residence. They needed to do some homework there and shower so they could be more ready for bed when they got home late, as it was a school night. Jennifer, their mother, turned the hot water off while they were in the shower and turned the breaker box off for the lights in the bathroom. When asked why, there was no real answer given. Jennifer was just upset at the lack of respect she was receiving from her sons. At one point, you can hear the middle child being disrespectful, and then Mom screams and a loud bang. A hit could be heard, and then he is heard screaming in obvious pain. The conflict kept escalating. The oldest son acted as a caretaker to everyone. The middle son was being targeted by Mom and told that he was mentally ill because he got angry when Mom kept telling him he was mentally ill. Jennifer explained to the boys that she is going to have declared mentally ill and file a lawsuit to take the money in their savings account. Jennifer continues that they will not be coming back to Mom's house and will be visiting here in a home for troubled kids that have issues like them. This home for troubled children that are mentally ill is where they will be from now on, when it is Mom's time to have them from now on. She repeated this several times to the boys until she gets a reaction. Once she gets the reaction, she mocks him. She explains to them that being called mentally ill would not piss you off if you were not mentally ill. This is coming from a woman with a degree in psychology from Boise State University and a psychosocial rehabilitation worker in the state of Idaho. This is coming from their mother. Imagine years of this as a child. At some point, you would do anything to make it stop. Then you see false allegation made against your father being believed by everyone. Then imagine that your mother takes you from a counselor's office, where you try to explain that it is all a lie and tells the doctors lies about you, to have you medicated and diagnosed just as she had threatened to so many times. You are defenseless and beaten. You must survive. This is akin to the training of young children in countries where they are indoctrinated to hate America and sacrifice themselves to please the religious zealots preaching hatred. This perspective should help you understand the seriousness of the problem. Many people do not believe it is real or understand how it can happen. The truth is that it is happening every day to many families. A ParentalConflict.com LLC was established because of the experiences James Feehan's children suffered due to PAS and the casual factors with a goal of prevention. James's experience, he was told by many 30-plus-year professionals, was the worst case they have ever seen. The duration and intensity of the experience offered perspective that aligns with his formal education, bringing a unique and hopefully valuable perspective to you. In 2010, he began learning about the condition. He researched the internet to learn more and found little information. You will find that most of the relevant information has happened since 2013. A watershed event happened on May 18, 2013, when the DSM-5 was published. This publication does not specifically mention PAS, but offers diagnostic criteria that can and should be used to formulate a case for prosecution of the abuse, whether in a criminal or civil proceeding. It is his belief that if the conditions that create PAS can be mitigated to the degree that alienation can be stopped, the conflict between the parents can be mitigated to a less unhealthy amount, creating a less toxic environment for the children. When the level of toxicity and conflict that affects the children is reduced to an acceptable level, both parents can be a positive force in the child's life, and the children do not suffer. The nature of particular high-conflict personalities can drive one to alienate children from a target parent. There is information on these personality types in Module 2, How to Conduct Yourself in a Custody Dispute. The two behavior patterns to focus on are narcissism and borderline. Diagnosing the other party is none of your business. If you want to motion the court for a psychological evaluation and pay for it, you may. You will be out about $5,000 and may have little to show for it. The identification of the two disorders is intended for you to learn strategies that enable you to interact with the other party in a manner that mitigates conflict. If the other party is truly disordered, life will filter the facts. It is normal for a disordered person to project their feelings onto the other parent. Projecting means claiming the other party is disordered and then doing exactly what you claim they are doing. Being non-reactive and understanding that the disorder is real, and the other person cannot help their perceptions and possibly their actions is a healthy perspective for a healthy person. Even though it hurts other people, they cannot stop. It does not matter how much you argue. If you are making accusations and reacting to their antics, you are participating in conflict. You have become a problem in the process and are perhaps flaunting a disorder of your own. You detach from the outcome of the other parent's behaviors. Their right to be dysfunctional or abusive is only hindered by action of the government. Allowing the behaviors to continue without any interference from you while it is being documented in a manner that can become admissible evidence is a proper strategy. This endeavor is not intuitive and I believe counterintuitive. A normal person's nature is protecting their children from any harm. No other person is exempt from your protection of your child except the other parent. They get the free pass because they are the parent and your protections are interfering with their parenting. Welcome to the new paradigm. No person is exempt from the chaos that a disordered person causes. No person is exempt from the stress of a custody case. Learn to focus on your self-care and the interest of the children. The children deserve the best from their parents. Stress of legal conflict and stress dealing with a disorder does not bring out the best in parents. There is a strong argument to stay out of court and seek help from the mental health industry. It is cheaper, healthier, and the consequences are presumably less dire for the children. The party that insists on legal action and does not participate in healthy interaction with the mental health professionals is waving a red flag. Defining PAS and common associated terms. Parental alienation syndrome is a term introduced by child psychiatrist Richard Gardner, and his definition is as follows: a disorder that arises primarily in the context of child custody disputes. Its primary manifestation is the child's campaign of denigration against a parent, a campaign that has no justification. It results from the combination of a programming, brainwashing, parents' indoctrinations, and the child's own contributions to the vilifications of the target parent. When true parental abuse and/or neglect is present, the child's animosity may be justified, and so the parental alienation syndrome explanation for the child's hostility is not applicable. He adds that programming parents who are accused of PAS will sometimes claim that the conditions are warranted due to bona fide abuse perpetrated by the denigrated parent. There are times the abuse the children claim has the parental alienating behaviors superimposed on events the children perceive as abuse. An example that is personal to me is a list of abusive behaviors my children listed to a counselor. My sons listed the following: drinking water with meals, avoiding dark sodas, going to church, and learning music as the abusive things that dad did to them. The thinking that happens by the children is that no matter what the parent did, does, or could do, the intent is evil and it is dangerous abuse, and the person deserves the least respect possible and the most hate possible. Showing disrespect and hatred is a family value in the home of an alienating parent, so long as it targets the alienated parent. A precise example of this behavior is the fabrication of violent abuse stories told by my children to counselors. They knew enough to not state it to law enforcement, but to strictly express these lies to counselors. This is a manipulative skill with legal implications that is not reasonable for children to know about. Parental alienation and parental alienation theory, and the previously defined parental alienation syndrome are terms that many use synonymously. The original parental alienation syndrome was intended to be the proper diagnostic name, and as such, capitalized when writing. Parental alienation theory is a proper name as well. The term parental alienation was a term that described what was happening that led to the syndrome. Parental alienation has now become to be the proper name of the legal definition of the old parental alienation syndrome in many jurisdictions. The point is to be aware of what meaning is being expressed by, and to mental health and legal professionals in your interactions. Minor miscommunications can have serious consequences in legal matters. When the terms are written, the use of capitalization of the titles should indicate their usage. There are 3 levels of parental alienation as follows. Mild. Child will initially resist time with the target parent but still enjoy time after parenting time is proceeded. Moderate. The child will strongly resist time with the other parent and maintain resistance and is oppositional during parenting time. There can still exist some positive moments and connection between the child and the target parent. Severe. The child is persistent in an absolute rejection of the other parent to the degree the child may run and hide in avoidance and, if forced to spend time with the target parent, will remain fully oppositional. At this level, the child will likely be actively recruiting more hate toward the target parent in support of the alienating parent. Here's a glossary of common terms related to this topic that should be understood. Splitting, black and white thinking, is the failure in a person's thinking to bring together the difference of both positive and negative qualities of the self and others into a cohesive, realistic whole. It is a common defense mechanism. The individual tends to think in extremes whereby they view an individual's actions and motivations as all good or all bad with no middle ground. This creates the environment for seeing the alienating parent as all good, no matter what, and the target parent as all bad, no matter what. Remember, this is a psychological defense mechanism that people develop to cope with this controlling type of abuse. In this example, it is the children coping with the chaos and conflict. The alienating parent is also referred to as the preferred parent, favored parent, or the loved parent, and is the parent who indoctrinates their child to fear or disrespect the other parent. The target parent is also known as the alienated parent and the rejected or hated parent. It is possible to be a target parent and not be an alienated parent. This can change as the alienator becomes more successful over time. 5-factor model is a method for identifying parental alienation by understanding the components of the problem that includes 1. The child manifests resistance to a relationship with one of the parents. 2. There is a history of a prior positive relationship between the child and the now rejected parent. 3. The absence of abuse or neglect to a degree justifying the rejection of the parent. 4. The existence of alienating behaviors of the other parent. 5. The exhibition of many of the 8 behavioral manifestations of alienation by the child or children. Alienating behaviors are activities of an alienating parent, including denigration of the target parent, limiting time with the target parent, and suggesting that the target parent is dangerous. There are 3 levels: mild, naive alienators, occasionally and unintentionally engage in the behaviors; moderate, active alienators intentionally engage in many of the behaviors and they resist to some degree the advice to stop; severe, obsessive alienator with behaviors persisting with full intent on destruction of the relationship with the other parent without restraint. Parental estrangement and hybrids is a child's rejection of a parent for a good reason. This differs from alienation simply in that a reason for the child's rejection of a parent, or target parent, can be connected causally to a behavior of the rejected parent. There is a continuum to consider balancing estrangement, and whether a rejection of a parent is to be blamed on estrangement or alienation. This estrangement idea is why alienators may help their children make false allegations against the target parent. Alienation, hybrid here in the middle, then estrangement. The marker for the situation can be further right or further left on the continuum. There is no perfect parent. Inevitably, there is likely an argument that almost every situation lies somewhere within the continuum. The argument is made in a courtroom with evidence. That evidence can include expert witnesses offering opinion testimonies that battle over which end of the continuum your particular case sits. Evidence can also include testimony of children, recordings, emails, witnesses, and likely more. The role of expert witness in more detail now. Expert witnesses offer opinions. Parental alienation is not a black and white issue. The gray area is the continuum line. Where a case falls on that line is an opinion, and no opinion is acceptable to a court without a qualified professional practicing their due diligence. All mental health professionals are not the same. It is imperative that you understand that a clear case of alienation can be mitigated to the point of losing all credibility by accusations of abuse against the alienated parent. Abuse takes on a new meaning in this realm as well. Whatever the child may perceive as abuse can be exaggerated and take on a life of its own. This is a primary reason to act fast and effectively. The counselors that interact with the children control the outcome of some of these cases. Considering an extreme situation I experienced where an incompetent and/or corrupt expert witness and the alienating parent accomplish long-term isolation of the alienated children from the target parent, include a counseling regimen and home environment that results in the children fabricating abuse by the target parent, that the corrupt counselor uses to conclude an opinion that the children sustained this fabricated abuse, and therefore the children were estranged beyond any doubt in the counselor's mind. The court believes the counselor. The target parent does not learn of the fabrications until years later. There was no possible defense to the accusation, because despite repeated requests regarding the specifics of the accusation, the counselor denies access by incorrectly claiming privacy law prevents this. The outcome of this case is very predictable. There is no defense to corrupt counselors that coordinate efforts with the alienating parent, Of course, I did not have these facts in the moment to work with. They evolved over time far too late to make a difference for my children. With the aforementioned information in mind, you almost always need an expert witness on your side that can make the case on the witness stand with appropriate and current facts, including current interactions with your children that provide credibility for the court's satisfaction. There are 3 components necessary for an expert witness to make the case in a courtroom that children are being alienated from a parent. The first component is current interaction and knowledge of the child or children involved. The second component is the education, certifications, and the current knowledge about parental alienation for credibility in a legal setting. The third component is the ability and experience to testify and withstand an aggressive cross-examination in an unbiased manner. This combination of traits is a rare find. You will likely be doing the best with what you can find. Selecting your witness and knowing the landscape of other possible expert witnesses that may oppose your case is what an attorney well-versed in parental alienation will have knowledge of. You will need knowledge of the mental health industry also. It is recommended that you become familiar with our information on the topic titled Mental Health Industry. How expert witnesses are able to bypass rules of evidence is important and discussed in this other document. The attorney and the expert witness as a team. You as a client should have a big picture perspective of what the professionals you employ must consider in representing your interest and the interest of your children. They have concerns of liability. They have a political structure in which they operate professionally. There are concerns of professional reputation, which can mean winning for you. There are rules and ethics that they are required to maintain consideration of. Finally, there is the case for which you hired them and the craft they practice in your interest. The mental health professional must be credible to the court after being cross-examined on the witness stand by opposing counsel. Your attorney and your expert witness will coordinate in detail regarding the direct examination, as well as cross-examination concerns several times before trial. Much of the discussion between these professionals should be considerate of the facts of the case, supporting evidence, opposing counsel, and their expert witness. A good expert witness will not testify unless they are confident that the facts they have are complete and correct. They will also need to know that the attorney they are working with is competent so that upon cross-examination, they do not appear to be a fool. The facts of the case are often known to all parties, and there is a disagreement of their interpretation. The supporting evidence has credibility of its own. Ensuring the facts of the case are complete is primarily the responsibility of the client. Withholding information from your employed professionals is a bad idea. You could be wasting their time and your money and risking custody by withholding facts or evidence. Professionals need a full picture to do their job. When they are surprised during trial, it is usually detrimental to their client. Depending on jurisdiction, attorneys deal with what is commonly referred to as Rule 702. This is a federal rule that governs expert testimony. Some states may have variations, but generally speaking, this is the rule. Rule 702, testimony by expert witnesses. A witness who is qualified as an expert by knowledge, skill, experience, training, or education may testify in the form of an opinion or otherwise if a. the expert's scientific, technical, or other specialized knowledge will help the trier of fact to understand the evidence or to determine a fact in issue. B. The testimony is based on sufficient facts or data. C. The testimony is the product of reliable principles and methods. And D. The expert has reliably applied the principles and methods to the facts of the case. This is one minor example of considerations. Your attorney is offering your case which could be transparent to you. Other considerations are the statutes and case law involved, witness scopes, evidence foundation, tactical questions, and conflicting evidence and testimonies. That is a conservative snapshot. The point is that they have the training to deal with the court in this complex situation. Offering honest and complete truths and evidence is necessary. Your expert witness is not just concerned with offering an opinion, but debunking the alienator's expert witness as well. Your attorney should be cross-examining the opposing expert witness to reveal a lack for credibility due to education, experience, certification, or being misinformed, uninformed or ill-informed regarding the facts of the case. Your expert witness is responsible, if possible, to debunk the opposing expert witness's conclusion. This process should be a team effort with the attorney, the mental health professional, and yourself. Debunking the expert witness requires more accurate and complete information than the other party has, as well as using better science. It can also be accomplished by simply pointing out the flaws in the other party's conclusion or thought process. Either party can be right or wrong. This may have no bearing on the court's decision. The person with the best information and process to a conclusion can win. The process of a trial is fluid and understanding. The judge's perspective is imperative. Objectivity is not a trait the client will usually have at this time. The professionals must have objectivity. If they do not, and they begin to see one side in a judgmental manner, your case is in danger. You should appreciate their discerning objective perspective. This battle of objectivity is also why having complete information is very important. Also, remember that facts in a trial are not always the truth. They are what the judge believes. It is also good to remember that evidence is important, and in parental alienation cases, gathering evidence can be detrimental. If the children become aware that you are recording the other parent, you then are sowing distrust in your children and involving them in the chaos that it is your job to shelter them from. It does not matter what the other party is doing or what they have exposed the children to in this process. You are still the responsible parent that shelters them from chaos and provides stability and love. For documenting evidence, I refer you to our module titled Evidence That Matters. Identify parental alienating behaviors by observing the following. The alienating parent displays specific behaviors responsible for triggering the child's or children's alienation from the target parent. These behaviors can be evidence for the mental health professional as well as persuasive to the judge. 1. A personality disorder, usually narcissism, borderline, psychopathy, and often a paranoid orientation to interactions with others. 2. Severe cognitive distortions, such as a belief that the target parent is dangerous despite evidence to the contrary. 3. Externalizing unwanted emotions and responsibilities. This includes blaming conditions outside of themselves for their feelings and actions. This resembles projection. 4. Display anger associated with an abnormal grieving process. 5. Enmeshment, an unhealthy relationship with their family of origin. These characteristics are motivators for the alienating behaviors, as they cause the alienating parent to misperceive and distort external forces as negative or dangerous. This distorted perception requires the alienator to react as if in survival mode, with a need to control and manipulate the children and other adults to create harm for the perceived threat of the target parent. Here's a list of the behaviors that manifest the personality problems that can be used as evidence to prove parental alienation. 1. Emotional abuse. 2. Using children as pawns. 3. Minimizing, denying, and blaming. 4. Economic abuse. 5. Using physical or sexual abuse. 6. Threats or intimidation. 7. Coercion. 8. Isolation. 9. Using privilege. In order to prove or defend allegations of parental alienation, there are several information sources that should be investigated to the fullest extent possible. This includes interactions between the children, the parents, the family, and other peripheral contacts. The non-exhaustive list is as follows: voicemails, texts, emails, audio recordings, notes, phone records, report cards, and school correspondence, medical and medication records, police reports, child protective services reports, court orders, prior court transcripts, psychological evaluations and records, therapy status reports, bank statements, photographs, logbooks, or journals. Collecting and organizing these records is the only way to offer a complete picture of the situation to the mental health professional and the court. It is important to view the evidence in an objective manner. I will say it again. This objectivity will not normally be accomplished by the client, and if the professionals are not capable of objectivity, your case is in trouble. This process is necessary to create an objective and evidence-based conclusion by the mental health professional and ultimately the court. We can offer insight and research for your employed professionals upon request. Your attorney may need precedents, and your mental health professional may need research that supports their findings. This we can help with along with other needs. If your professionals are sole proprietors, they may appreciate the resource. They can contact us, or you can let us know if you need, and we can discuss the research fees. The plight of the child being alienated is bleak. Children who experience an environment where alienating behaviors exist experience great stress. Their loyalty is challenged. They are being forced to choose a parent in a most malicious manner. They are forced to reject one parent or be rejected by the other parent. This is considered emotional abuse. The intervention and remediation of the abuse can be more detrimental in the short term than allowing the abuse to continue unabated. A problem of pragmatics exists as the courts are typically short-sighted in perspective and limited in their powers to control the abuser's behavior. This leaves few options for courts to remedy cases consisting of parental alienation syndrome. Early intervention makes the job easier. Quick identification of the problem and court reaction time is a problem. Preventing the entrenchment of alienation early is paramount. This requires quick action by the target parent to motion the court to direct structured psychotherapy with both parent and child education programs. The orders should be detailed and unambiguous. The role of the mental health provider should be clear so as to hold each person accountable. The child's presence in the counseling sessions with the target parent should be specific. The requirement for the presence of both parents with the counselor in the office at the same time needs to be written in the order specifically. The frequency and purpose of the therapeutic visits should also be specific in the order. Details left unspoken are left to the interpretation of anyone, which would require refiling a motion to compel delay in the process, resulting in further entrenchment in the alienation process. A statement in the form of an affidavit or testimony from a mental health provider that is involved in the case may be necessary to accomplish an order respecting the importance of expediting the remediation. Rapid and effective enforcement of the orders is important. There will be resistance at every turn from the alienator. This is their role in the process. You can't judge them because they truly cannot help themselves. You need to understand they are driven by mental health issues. Your reaction to them determines your fitness in the eyes of the court. Not reacting to their antics in any way other than court filings and care for the children is proper. This will also reduce your stress levels. You are responsible for your behaviors only. Remembering the child having stability without you reacting to the other parent's abuse will bring the child peace and a sense of security. Offer no reason for anyone to have a reasonable thought that you are anything but kind and stable, regardless of what the other parent is doing. Put yourself in the role of your child. Consider the perspective of the judge as a neutral observer. During the child's ride through the system, they can be left with the alienating parent, placed with the target parent, a bit of both in a graduated fashion, and in some extreme cases placed in foster care to stop alienation, while being reunified with the target parent. Hopefully, you will have a qualified mental health professional assisting the court's decision-making. Strategies that have been used with some success with the court. Ordering the rejected parent leverage in securing the child's compliance. For instance, ordering sole authority for consenting to a child's driver's permit for driver's education or exclusive control over a child's use of cell pony use. The alienated parent now has control in the child's life, even though the alienating parent may not want them to. This will enable the targeted parent communication with the child, and generosity from the target parent can be leveraged instead of squandered or mischaracterized by the alienating parent. The child honestly does not know who to trust. Offering the target parent the opportunity to parent without interference may offer clarity as to the character of the target parent for the child. There is no evidence supporting the efficacy of treating severely alienated children while they remain primarily in the custody of their favored parent and out of touch with their rejected parent. Weekly outpatient counseling as an intervention results in little benefit. Not only is this unlikely to be effective, but it will delay or prevent the actual intervention and remediation that children need. At the same time, courts are often reluctant to remove a child who is otherwise doing well from the alienating parent. When a child is severely alienated, repairing the relationship with the target parent will likely require extreme measures. One example of this is the multimodal family intervention, MMFI. This approach can require a team where each family member is assigned their own counselor, and in addition, there is a family counselor, and then yet another professional that reports and coordinates with the court. The level of success in severely alienated cases using the MMFI team is not promising. Sometimes the court can inform all parties that a failed course of therapy will likely result in increasing the child's time with the alienated parent or in a reversal of custody. This would be intended to motivate the alienating parent to participate in a meaningful manner and to encourage the children toward progress in the therapy. The solution with severely alienated children is primarily with the children spending more time with the target parent and less with the alienating parent. That is a simple solution. Courts are at times reluctant to make this happen for several reasons. One of these reasons will inevitably be the allegations of some sort of abuse against the target parent. Although often these allegations are false, the court might not see this fact until alienation has been set in stone. Timing is critical. In the most severe cases, there is an educational alternative that could help. It is another option that you can research if needed. The theories used are similar to common sense but offer a rigid structure to control the circumstances for better therapeutic responses. It is called Family Bridges, buildingfamilybridges.com. It is a workshop with the child and the target parent only. There is no contact with the alienating parent for this time period. The results are impressive. There are circumstances where the child will be placed with the alienating parent and remove contact with the alienated parent. Help is unavailable, unaffordable, or deemed ineffective. Various reasons can facilitate these circumstances. Be careful, act swiftly, and avoid any action that can be interpreted as abuse by anyone, including the children, at a later date. This cannot always be accomplished, but be careful and aware. Act swiftly at the first sign of alienation. This will likely be hearing about the other parent speaking negatively of you. Refer odd behaviors and disciplinary issues to a counselor the children see, and if they are not seeing one, start. The information and perspective from an objective party can prove valuable. You also need to remember to document the issues. The counselor should be documenting. This should happen as soon as possible. Remember that it is not about you, it is about the children. Regardless of the pain you feel, the true damage is happening to your children. I hope you and your children live a happy and healthy life. Remember, coaching is available at parentalconflict.com.